Okay, welcome back, everybody. So just a quick reminder as to where we are. I've just made a note of this while we were on our quick break. The vote was 54 in favour of discrimination claim being successful, 54 plays 35. And for the harassment, the vote was 20 that yes, she would, versus 65 that no, she wouldn't. So obviously there's that. At the moment, that first perception was more likely to win the discrimination claim, less likely to win the harassment complaint. Let's see what changes, if anything, as a result of Agnes being cross-examined. So for those of you who clicked away from the Mentimeter after the last one, let me just reshare my screen as far as the voting code is concerned. For those of you who still have it up, you can go to the second round of voting, and I'll click onto that in just a minute. A change, Stephen.
That's a big swing, isn't it?
Isn't it?
Good.
I feel like John's now.
Not biased at all. I think this is an important point, though, Vicky. Is I say this to witnesses when I'm in tribunal, and it's I don't like referring to football analogies, but it really is a game of two halves. You'll see the mood of the tribunal swing. You think you've done really well, and then by the time the claimant comes on, you think, oh dear, or vice versa. You think you've not done so well, and then suddenly you put your witnesses on, and you feel that it's balanced out, and you've done very well. So
yeah, quite so.
It's good to see this actually, because it reflects reality,
doesn't it? Just yeah, absolutely. So we've got so let's capture this at 2161. I appreciate there might be one or two people voting, but I don't think it's going to change the broad balance. Let's go on and have a look at harassment then. See whether this changes like the discrimination one has done. So will Agnes win her claim of harassment? They're coming in thick and fast for the nose.
Yes.
And actually, it's
Very
consolidated the previous view, isn't it? This one,
yes.
Interestingly.
Yeah, absolutely.
Okay. So let's crystallize that one at 6 and 76, and I'll put this up on the board in just a minute so that we've got it when we look at it and ask you to vote for the third and final time. Thank you, everyone. That's great. I will stop there, and let's go on and have a look at then the evidence on behalf of the respondent. So the process is effectively the same. We have one witness on behalf of the respondent, and of course he's giving evidence on his own behalf as well. Remember, we've got two respondents here. So exactly the same would apply. His witness statement would be taken as read by the tribunal. He will be asked to take the stand, take the oath or affirm to say that his evidence will be the truth. He will be taken to his witness statement, asked to confirm that it's his signature, and then he will be handed over at this point to the claimant's representative, who is played by another of our colleagues, Tim Cross, to cross-examine Mr. Fletcher, aka Stephen, in his capacity as the line manager. So we're going to see this evidence broken down in a few parts as well, just as we've seen the claimants. So we'll have a look at the couple of sections. But Stephen, just talk us through this, because from a practical perspective, of course, you don't know at this point whether the claimant has discharged the burden to shift the responsibility onto the respondent, because the judge doesn't make any findings at that point.
No.
So how is this dealt with practically in that light?
In reality, the tribunals at the moment have become slightly more cautious in that what they'll do is that they will hear all the evidence. Once they've decided that there is a case or potential case to answer, they're very unlikely nowadays to strike a discrimination case out, which is disheartening, because some of them you do feel don't have legs to stand on, but only in the most obvious of cases will they strike out nowadays. Generally, they want to hear all the evidence before making a decision. And that's where we find ourselves. You may or may not feel that the burden's being discharged, but in this case, there's enough there that they will want to hear the respondent's evidence now.
So the respondent's case is going to work on the assumption that the claimant has. So the preparation works on the assumption that
Absolutely.
the claimant has discharged their burden, so that they have to prove the negative. Yeah.
Yes. And that's
how?
Sorry, I was just going to say that's the best way to be, because if a decision has been made, you should be able to explain that decision, and you should be able to back it up in evidence. And I think a number of delegates today have already realised that we're light on the documents.
Quite
so. Word against word.
Yeah, quite so. And there is plenty of case law as to actually how high this burden is, Stephen, isn't it? In terms of evidentially, what does the employer, the respondent, have to establish here?
Yeah, in simple terms, it's a clear reason. What's the reason? If it wasn't to do with the protected characteristic, in this case, ethnicity, what was the reason? Now, it does sound like a high burden, but actually, remember what I said before, even if it was a bad decision, provided it's nothing to do with that protected characteristic, that can be your defence. So it feels like a high burden. It's often you feel like you're trying to prove a negative. But actually, you just need to be clear on what your reason was, and ideally have a contemporaneous note.
But it has to be for no reason whatsoever related to her ethnicity, does it?
Yes.
So it doesn't matter that it was unintentional or unconscious. So, all of the good discussions we have about unconscious bias, for example, have good reason, because actually we want to make sure that there is a conscious decision making that is evidence that's got nothing to do with that person's, in this case, ethnicity.
Sorry, that's an extremely important point, not just for discrimination cases, but there's just been a very recent case. If you read our In View monthly article, there's just been a one in relation to protected disclosures. And that's exactly the point. It doesn't have to be the reason or even the sole reason. It has to be not tainted at all, effectively, in the decision making.
Yeah, absolutely. Now, let me just pick on a really interesting question here on the chat, Stephen, before we go there then. Can strikeout happen prior to the respondent giving evidence? So on the day of the hearing, as opposed to, say, in preparation or as part of preliminary hearings?
I would say technically, yes, it can. Normally, if you felt the case was that weak, you would be asking for a preliminary hearing. So before we get to the hearing where there's full evidence being exchanged, you would normally ask for a preliminary hearing for the judge to decide whether or not the case has reasonable prospects. And you can ask for two things there. One, you can ask for a strikeout, which is extremely draconian, or you can, if there's doubt, you can ask for the claimant to be ordered to pay a deposit, which is a good tactic. And a deposit is a sum of money based on their means. But what it means is that two things. One, they lose their deposit if they lose the claim, or an element of the claim that the deposit is placed against. And more importantly, at that point, they're on notice that they could be responsible for your costs, your legal costs and otherwise from that point on. So it has an extremely persuasive factor. So often apply for a strikeout, definitely apply for a deposit order. You're more likely to get the second nowadays than the first, but that would normally be dealt with before you could turn up for the full hearing.
Yeah.
Don't be afraid to push for that. Lots of judges are, particularly the newer judges, and I apologise to any that might be on here, or part-time judges, but you find that the confidence comes in the more experienced judges, in that they are familiar with what the test is and be prepared to be challenged. A lot of less experienced judges will prefer for the judge at the final hearing and then just say, well, we're going to hear the evidence, we'll hear at the final hearing. don't be afraid to push your advocate to push for a preliminary hearing.
Absolutely. And there's an interesting question here. Is it not a barrier to justice? It's a really interesting point. And in theory, you could say, yes, it is. But what it's trying to do is strike the balance with the fact that obviously tribunal hearings are free to access. And therefore, it sort of creates an expectation, if you like, that people go to and use the court resources and put employers through the burden of a hearing when they feel strongly and are able to demonstrate with evidence that the case that they have in front of them. So it's trying to address in any way it can without requiring fees, if you like, for people to take the process seriously.
It's used in the most extreme cases. So in order to put people's minds at rest, yes, justice comes absolutely first. Deposits are rare. Strikeouts, particularly in discrimination cases, are extraordinary. Yeah. So it's protection of the public purse only in the most obvious of cases.
Yes. Yes.
The other point there is if they're supported by a union. Funding is a common thing that claimant lawyers will discuss with their clients, but that is often subject to a 51% success test. So if they bring the claim, that may proceed to a certain point, but the unions will often cease to support and other funding sources if there's not a 51% or more chance of succeeding.
Great stuff. Thank you. Okay, so let's see the respondents' evidence in action then. So what we're going to see is cross-examination of Mr. Fletcher, aka Stephen, as I've mentioned, by my colleague Tim Cross, looking at, first of all, at the discrimination complaint. So we'll see it in 3 sections, as we have done, 4 sections in this instance. We're going to have three different sections around the discrimination complaint, and then we'll see 1 section relating to the harassment complaint. So just to kind of break it down into bite-sized chunks. This first one is looking at the defence that the claimant's selection was not unfavourable to her. So what Tim Cross is doing here as the claimant's advocate is challenging that point, that it wasn't something that it was unfavourable to the claimant by selecting her to look after this emerging market. So let's have a look at what we've got here.
Good morning, Mr. Fletcher.
Good morning.
You have in front of you a copy of your witness statement. At the bottom of that statement, it confirms that the content of this statement is true to the best of your knowledge and belief, correct?
Yes, correct.
Yeah. And you're an experienced manager, having started with the company in 2016, correct?
That's correct, yes. Business development manager, I was then.
Yeah, so that was the same job as the job that my client's doing, correct?
Yes.
Yeah. Would you regard yourself as a straightforward and transparent individual when dealing with work-related matters?
Yes.
Yeah. Is it fair and would you also regard yourself as a fair and reasonable manager?
Try to be, yes.
And you would accept that it would be wrong to disadvantage or harass people because of their race or nationality?
Of course, yes.
And you'd also accept that as a manager, it would be incumbent upon you to set targets that are realistic, reasonable and achievable?
Our sales team are driven by targets, yes. Mm-hmm. I wouldn't say that they're unreasonable.
It would be correct, wouldn't it, that if targets were not adjusted to account for a particular difficulty, then it's possible that those targets wouldn't be achievable, and that if so, targets aren't met, that would result in a financial detriment in terms of lack of commission and so on and so forth.
There is a detriment if people don't hit their targets, but they can be adjusted if circumstances change or the economy changes.
Sure. And when appointing my client to the business development for the new untapped Polish market, it's correct that you didn't make any adjustments to targets at that time?
We didn't. She seemed happy to accept the new role. She didn't raise the issue. We didn't cover that, but it's something we could have looked at had that become an issue as she developed the market.
Would you accept that it's particularly difficult to break into an untapped market in a foreign country if you're not fluent in the language, you can't read or write in that language, or if you've got less or limited experience of developing an untapped market?
only if they were requisite for the role. You've got to remember that hotels have staff that are fluent in English, and therefore her English was adequately fine to converse with those in Poland.
And in terms of my client's background, it's correct that she's not Polish, isn't it?
I would say that my understanding is that her parents are Polish rather than
Parents are Polish rather than her. She's British.
Yeah.
It's correct that she's not fluent in Polish.
I wouldn't know that. As I said, that wasn't part of it, but I wouldn't know.
Okay, I'll put it to you that's the case. And it's correct also that my client doesn't read or write in Polish.
Again, I wouldn't know, but that wasn't a factor in my mind at the time.
Okay, but you wouldn't disagree with that if, as per what the claimant said in her evidence.
I can't agree or disagree. I've never asked or seen her required to speak or write in those languages.
Okay, I'll put that to you. That's the case. In paragraph 8 of your witness statement, you say, I remember saying to Agnes that she would be the ideal person to take on the task given her experience before joining us. What experience are you referring to there?
Sales experience, just general sales experience, yes. Okay. Very, very experienced, very, very driven. That's what led me to appoint her, really.
But you've heard my client's evidence where she herself suggests that there is other people within the team who'd be better placed to develop sales in an untapped market. Some of them have had developed new markets in the past, which suggests very much that she hadn't, and there were other people that had. That's correct, isn't it?
That's your suggestion, but that's not correct. No, the simple position is that people within the team have developed markets, as she could have done had she stayed with us.
She could have done. So can you give me an example of where she said she has done?
No, as I said to you, it was the experience that she had. And if you look at her statement, she does actually accept that part of her role is to develop growth of existing clients and to develop networks and new clients. And this would fall into those latter two categories.
Slight difference developing an untapped market, is there not, Mr. Fletcher?
So sales is sales, and sometimes you need, even with existing clients, you need to make cold calls to develop that. It's the market changes nothing. The language is the same.
Just so I'm clear, you accept that it's correct that other members of the BD team did have experience of developing the new untapped markets.
They were given the opportunity and were able to develop, and I'm sure Agnes would have been equally able to do so on her sales experience.
Okay. Now, you say in your statement.
I'd just like to add, the reason why I didn't move those people was that because they developed those markets and gained relationships, it didn't seem appropriate to move them from that new market to another new market. It was to give Agnes the opportunity to do the same.
So this is our first point then. How successful has Mr. Fletcher been in establishing, oh, this wasn't detrimental to her? Thoughts, anyone?
Whilst you're thinking about that, I'll just type in some comments first, possibly. A good point to note at the beginning, it's slightly deliberate on my part, maybe over-exaggerated, but you'll see that it took time for this witness to warm up. You'll see barristers and advocates asking very close questions, and if you ever attend Vicky's training, you'll know the benefit of what she talks about as a sandwich, where you start with an open, you've got your closed, open, closed questions. These were very close questions, and basically were pushing me to say yes or no. And we do witness training that helps you wiggle off those points, but it's a very important observation. So if you saw nothing else in that section, you don't want to be the person that's being pushed to say a yes or a no when that's not what you want to say. And go in warmed up, have your explanations. It took at least 2 minutes before this witness warmed up.
Absolutely. And you may feel you've lived and breathed this case before you arise, but it's always worth having another read over your witness statement, isn't it? All of the documents, remembering where everything is, so you don't have that brain freeze moment that we've all done, haven't we? You know, outside a tribunal or in it, and that's thinking, oh, I can't remember what date that was, or I can't remember when that, you know, because our brains, when we're under stress, have you know, ways of causing a strain in that sense. So yeah. So some interesting points here about it could have been detrimental, not that it was detrimental. So what you're looking for here is unfavorable treatment. So you're not necessarily looking for a tangible evidence, but something where somebody felt that, and a reasonable person might feel that this person has been subjected to some form of detriment.
There's an important case on that. I think it was about 2 years or just before the lockdown, in fact, where the police had moved a pregnant lady to effectively an office-bound role following a risk assessment, health and safety risk assessment. So it was done for all the right reasons, but actually she perceived that to be limiting her career prospects, and therefore, again, they were facing a discrimination claim. So it shows you even the right reasons can still be discriminatory.
Quite so. Good. Okay, so let's go on and see where the cross-examination goes from here. So what we'll see next is Tim taking the next element of the evidence that he needs to put to Mr. Fletcher. You'll have heard him actually in a couple of areas saying, I put it to you, I'll put that evidence to you, so you don't disagree. And that's the technical point that Stephen was talking about earlier in terms of putting some of this evidence in front of the witness, because otherwise the judge will take it as being accepted if it's not done. So that I put it to you is technical speak to do exactly that.
Another point I would note there, and again, partly witness training, is Tim was very good in repeating. He put the point to me. If I didn't agree, he put his point, and he left that last message in the tribunal's mind, which is a technique you need to watch. Don't let the advocate do that. You need to say, no, as I've just explained to you, I can't comment either way.
Yes.
It's not for you to say whether evidence accepted. I simply can't confirm.
Yes.
And the judge will normally step in then. And I've even heard judges saying, look, why are you asking this witness? If they say they don't know, they don't know. So don't be afraid to challenge the advocate. You sometimes feel on the back foot.
Yes.
The evidence is yours. You keep control of it.
Yes, quite so. Because for those of you that have ever sort of delivered or been involved in any kind of presentation skills training, you remember that the last thing that somebody says in a presentation is something that sticks in the mind. And that's exactly that same principle being sort of played through here in this context. So the next thing we're going to have a look at is the challenge that she was the best person for the job. So the defense, you'll remember, is that she was selected because she was the best person for the job. So we're going to see that part of the evidence now being challenged in cross-examination. So we'll go to that bit next.
Okay. Well, talking about relationships, you talk about the communication problems that my client had. It's correct that you failed to address those alleged communication problems with her.
They have been raised by clients. She was new. I think she'd only been in the business for 2 months. I didn't really want to upset her at the early stages, and this was an opportunity both for the business and to resolve any potential conflicts that had arisen. And therefore, I was killing 2 birds with 1 stone. So that was one of the main drives, really. It was an opportunity for her and to resolve an issue which had arisen.
Okay, but you didn't raise the problems specifically with my client, did you?
I didn't. It was just one of those issues which had come up, and I wanted to give her the opportunity to prove herself rather than address an issue which had been raised.
Okay, and you say in paragraph 3 that one of the issue was that had been raised by one of the clients was the tone of her emails over the phone, and that she came across as abrupt and rude. How so?
Just very curt. In sales, it's all about developing relationships, and she seemed very blunt at times, very curt with people. And I'd found that myself as a manager on the odd occasion when we'd spoken. She could be like that on occasion. So as I say, one of those things, and an opportunity arose which would help us resolve, the needs of the business and avoid that potential issue arising again.
In paragraph 4, you put those shortcomings down to what you describe as, quote, a cultural difference.
Yeah, it just seemed to be her way. She was very direct. She was very, at times, curt. That just seemed to be something that I've noticed. It can arise culturally. It's just a general comment, but it was something that was coming to the fore, yes.
And in paragraph 9, you again make the same point, the communication style, and as I thought, it might be cultural.
Yeah, might be. Not that it was. It just might be. I mean, people can be abrupt, irrespective of their nationality, etc. But she was English.
Well,
she just appeared to be abrupt with people at times. And I say sometimes, not all the time. So it could be any number of factors. But sometimes she was abrupt and painful.
There's no ambiguity in what you say, is there, in paragraph 4? I just put it down to being a cultural difference, is what you say in your statement, isn't it?
I do say that, but when I made the decision was to address the concern clients had raised, and that there was an opportunity. That wasn't.
It's not what I'm asking you, Mr. Fletcher. What do you mean by being a cultural difference?
Well, we all have our backgrounds and cultures, and sometimes your way of addressing people can be influenced by your upbringing. So possibly that's what I mean by that.
So the cultural difference, you're talking there about my client's Polish parentage, aren't you?
Potentially, yes.
Yeah.
But it's one of those things. I wasn't putting it down to that. I just had clients complaining, and it was a way of resolving it. It was a pure business decision. Nothing really. Nationality wasn't in my mind.
Well, let me take you to paragraph 9 of your statement. You go on and expressly say it seems a good fit for her to develop markets in Poland, as that's her nationality. So clearly nationality was in your mind at the time that you made that decision, was it not?
Yeah, I made that statement, sometime after I'd made the decision. The real issue was I had a complaint from a client. We had a new opportunity in Poland. But on reflection, it does seem like a good fit, yes.
So I asked you at the beginning that your statement was true and accurate to the best of your knowledge and belief. Are you now saying that this statement's wrong?
Well, it is true. She's got Polish heritage. I've got Chinese friends, and they understand the culture and behaviours and saving face, for example. It's a natural fit. It's not. That's not the reason for the decision.
But the point is, Mr. Fletcher, you're criticising my client's communication skills or lack of them due to cultural differences, aren't you?
I'm not criticising her at all. My clients have raised issues with her communication style,
which you are attributing to, quote, cultural differences, aren't you?
It may have been that, but this was an opportunity to help her develop her career with ourselves.
Oof.
Interesting, the body language. Even though I'm role acting, you can see how uncomfortable I am, jigging around on the seat, and feeling with my face. The body language has completely changed. So again, important to watch as well as listen.
Absolutely right. Absolutely right. And of course, the judge will be taking all of that into account.
Absolutely.
When they're hearing that evidence. So talk to me through the process then, Stephen, in terms of decision being made, statement being written, statement now being cross-examined on. What's gone wrong here? What's
gone wrong is I don't think this witness has either read his statement since he just rattled it off, or he's not had it read independently. It's got to be your statement. It's got to be true, and it's got to be accurate. But you've got to think about what you say. So you can see even the slightest word here can be leapt upon by the lawyer, or even just a lay representative. and that has put me in this second section on the back foot. So I should have just stayed with my decision at the time was I had a complaint in from the client. Let them pull out the bit about the cultural background of the parents, etc. Don't try and explain things later. Just say that was my reason. That was a clear decision. The more you expand, the more you'll get questioned, and that's a classic example in this cross-examination.
Lovely. Okay. Some comments on the chat coming through here. He should have tackled her communication skills at the time. Absolutely right. Absolutely right. If that had been addressed, would we even be here in the first place? Yes, and an interesting point. I'm afraid, Mr. Fletcher, your statement is being perceived to be more weak now. Now you're being cross-examined.
Good, very good. But this is a classic, isn't it? And I know you do a lot of training along this lines. Is that difficult conversations? Nobody wants to have that conversation. It is difficult, but there's a way of doing it. You can say, look, I've had a complaint in. We've got an opportunity, etc., etc. Document that, unless we'd have put this case in a completely different light. And
it could be that the two are entirely coincidental. It could be, but it certainly doesn't look that way with the benefit of this lens being put over it. And there lies the challenge, doesn't it, in that sense? Yeah, absolutely. And it could be, on the other hand, that the claimant has jumped on Mr. Fletcher's unconscious bias and scapegoated him. On the other hand, it could have been, absolutely. She could have been felt under pressure and thought, actually, I'm going to kind of extricate myself from the situation, and it's somebody else's fault, it's not mine. That could equally be the case too. I can see that, but the link between the incidents is becoming challenging here, isn't it, as this evidence is coming through? You could have strengthened this position so much easier, and we're limited by time, but you could have been clear to say, look, here's the complaint, sat down, had a conversation with her. The logical solution was to move her from that client and to move to, we had an opportunity, and then make no reference to the name, and then you could have, that point we made earlier, whether she married with that, gained that name through marriage or through family, it's irrelevant, absolutely irrelevant. It was just a natural business decision, which was nothing to do with the ethnicity. Yes. But this person's dug himself into a hole through a poor statement. Yes, indeed. And so the last part of the cross-examination on the discrimination complaint is really to make this link. So we've heard in cross-examination that there was a suggestion that there isn't a link between her being her heritage and the selection. This last section of cross-examination is absolutely looking to try and establish that that's the case. So let's have a look at where Tim goes with this one in terms of cross-examination.
You obviously say again in paragraph 9 that that's her nationality. You accept that that's incorrect, and it's an incorrect assumption on your part, wasn't it?
It's probably not the right way to phrase it, yes. Yeah. But it's true. She has Polish heritage, yes.
Well, she doesn't, does she?
She's a Polish parent.
She's a British national with Polish parentage. Yes. You assumed Polish nationality because of a surname, didn't you?
No, I mean, obviously I'm aware of a name, but the main thing was in the office she often talks about her parents and their Polish upbringing and when they came across. So I'm aware of it more from that than, I don't make a presumption from her name.
Isn't it fair to say that you made assumption about my client's nationality and suitability for that business development work in Poland?
I don't accept that, no.
Would you accept in hindsight that the client wasn't necessarily, as you say, the best suited for the Polish work if she was not Polish, doesn't speak fluent Polish, cannot read or write in Polish, and has or lacks less experience of business development in an untapped market than other people?
I can only tell you what I said before. She's experienced in sales. She's experienced in developing new sales. The requirement to read or speak or write in Polish was not a requirement for that role. The hotel industry is infamous for their ability to speak and converse in English, and that's all that was required.
You'd accept that placing her into that role without adjusting her targets represented a disadvantage to her.
But as I say, that's something that we had a conversation. She never raised the issue of targets, and that would have been reviewed as things progressed within the financial year. Those adjustments can be made. They weren't made. I will accept that they weren't made at the time of the conversation, but this was very early stages.
Okay, so that takes us to the final point then that they were looking to explore with Mr. Fletcher. Stephen, thoughts on where we've got to here in terms of how this evidence has come across?
I'd be interested to see what other people think on that, but my what I would observe is when a judge is listening to the evidence, they're also observing the behaviours. So I'd be interested in, when we pick that up later, I don't know whether, I think we're having another vote, but it'd be interesting to see who you preferred. Forget too much what they're saying. If it's one word against another, why you prefer one person over the other. I know my views on that, but I won't give that away just yet. But I think what this witness did do is he was quite clear and categoric as in what was required for the role. So you see the witness is warming up, but I think he's lost the edge. It's too late into the evidence. So yeah, I think try and repair a bad thing here, did so a bit better, but far too late in the evidence.
So we need to look at the final part of the evidence, which is in relation to the complaint of harassment. And remember what Mr. Fletcher said in his evidence is he can't recall making that statement. So, of course, Tim's role as Agnes's advocate is to challenge that perspective and see if they can discharge the burden, which is say it's more likely than not that it was said. So let's have a look at how this was handled, how this is handled.
You accept that if you mock someone about something, it might cause them upset or offence?
Well, you say mock. I don't accept that I've mocked anybody.
I'm not asking you that. I'm asking you if you did mock somebody about anything, would you accept that it could cause somebody upset?
I accept people can take offence at times, but certainly don't believe that I mock anybody.
Okay. There's something that I'm referring to, could be anything, couldn't it? It could be a hobby, it could be someone's background, it could be their appearance, it could be the way they're dressed.
It could be.
Yeah. And it could also be their nationality or a combination of things.
It could be, then yes, it could be a combination of things, yes.
And you'd accept, would you, that it's correct that if you upset or offence could be more acute if you were being mocked or teased in front of people that you hadn't met before?
It would change the circumstances, but that's not what this is we're talking about here. This was a team that which she was part of, and she yes, we'd been in lockdown, but we'd all come together, and it was an opportunity for us all to meet. It wasn't a team she didn't know, it weren't people that she didn't know.
Well, let me take you to paragraph 11 of your statement, the second sentence. You say, I said it casually when we were all remarking on having either not met or seen each other in such a long time.
Exactly, such a long time. And COVID lasted quite a long time, didn't it? So we hadn't seen each other. But what you're assuming there is that I've said what she alleges, and I haven't. Okay.
So you do accept that in relation to the incident on the 29th of October, that you made comments about my client my client's dress or appearance?
I said something. I recall saying something about a suit, much as I would say to another friend of mine about his ties. It was just a nice comment about the tie. So
you made comments about the way my client was dressed.
I don't recall saying anything or connecting it in any way with regard to her nationality or anything you're trying to imply.
Okay, and in that sense, you say very importantly that you cannot recall referring to a nationality.
No,
it's possible that you could have done then, isn't it?
I wouldn't. These things happened some time ago. I don't recall saying anything like that along those. Normally, I would just say, "Well, that's a nice suit," or "That's a nice tie."
I accept that you're saying that you don't recall referring to a nationality, but it follows, does it not, that if you can't recall having done something, it's possible that that something could have happened.
I don't accept that, no.
You don't accept that.
I don't accept that. You're making an assumption. You're implying either way. I'm just being honest with you to say, look, I can't recall every word I've said in a casual past, but I do recall commenting on a suit. I don't recall, as far as I can remember, relating that to a nationality. I'm not even sure how I would have related it to nationality, even if I had.
You have seen my client's statement in relation to the complaint that she makes. She's very clear in her recollection, isn't it, that you made reference to a quote Polish power outfit.
I don't recall saying that. No.
No, precisely. She's very clear. You don't recall, do you?
I recall making a comment about a suit. I can't recall precisely what was said, but I can't imagine I would have said anything or how I would have related that to a nationality.
Thank you. No further questions.
Thank you.
Okay, so let's explore what's gone on here, because of course what Tim can't say to you as Mr. Fletcher, can he, Stephen, is you're lying. No,
there's a degree of formality and respect, but I think the last comment in the chat has said that surely manager here, if it's his character, would strongly refute it rather than not recall it. And this is extreme. This is the most important lesson from this section: is you've got to be categorically clear, because it creates room for doubt. And as Tim said there, if you can't remember, then you can't then deny it. So you need to be clear. You either remember it or you don't.
Yeah. And what Tim is offering the judge here is, well, which is the better quality evidence? Agnes has been very clear, he said, but you just simply can't recall. Make the choice. And of course, this can be equally relevant when you're conducting internal investigations, can't it, Stephen? If you have witnesses in investigations that say, I can't remember, look at what else they can remember around it and question how plausible it is that suddenly they can remember exactly what they had for breakfast, what they wore on that morning, but then in that row that they had in that meeting, that was the first meeting of the morning, they can't remember what they said. Just doesn't seem to ring true, does it?
Absolutely not. And I think some of you again on the chat said, what is a Polish power suit? If this had been a grievance and I was investigating that's the point I would have made to the claimant as well. Don't be afraid just because they're offended by it. Actually, you can dig on that and say, well, what does that mean? I've not heard that phrase before. So you can create doubt either way. So be very, very clear what you hear, what you see, and if you didn't, explain why. And that's what I think this witness does poorly, is that he denies things but then doesn't explain the reason as to the thinking or the reasons behind his denial. Don't be pushed and pulled by the advocate. I think it's a lesson here, and be very, very clear.
Lovely. So aside from any re-examination, which would be to address any points of lack of clarity or questions from the judge, this would be the end of the evidence that was available for the judge to make their decision. So what we're going to do now is take we'll call it a mini break, if that's all right. So we'll take it until 4 o'clock, and then immediately after the break I'll run another quick poll, because that will help us sort of decide where this decision is going to go, and we'll have a look at closing submissions, and then the last section of the day is that you will hear the judgment from the case based on the guidance that you give us on the closing submissions. So stay in the call as before. Let's get into the right sort of experience and practice, as Stephen said last time. Stay in the call, just pop yourselves on mute, and obviously keep cameras off, and we'll do the same, and we'll see you on the hour, and we'll run another poll, see where we're at. See you at 4.
Perfect.
Welcome back, everyone. So home stretch. Let's see what our thoughts are having heard from all of the evidence. So I'm just going to reshare my screen and flash up the QR code again in case you need it to go back onto the Mentimeter. If you're already there, feel free to start voting on that first question. So the third time of asking, will the claimant win her direct discrimination claim? And I'll go to that in just a moment. Give you a chance to re-click on if you need to. So it's settling there, 57 in favour of yes, I think, Stephen, don't you?
Yeah, I'd be interested the reasons why actually when we did the submissions point.
Absolutely right. So let's go 17 in favour of no. I don't think it's going to change on the basis of any other submissions here. Let's go on to the next one then. The third vote then of the harassment. Will Agnes win her claim of harassment? Much more balanced compared to previously. Shall we settle it there? That normally triggers a flurry. Okay, I think we're settled there at yes 26 and no 44. So we've got a consistency in terms of the harassment complaint throughout. No's each vote. And we've got a change, yes, no, and then yes on the harassment complaint. Well, that really helps the judge. Thank you very much for that. What we want to have a look at is the submissions, therefore. Stop sharing that for a moment. So, Stephen, talk us through closing submissions, and then we'll have a look at doing some, shall we?
Yeah, the starting point is Darren, our chairman. He always upsets me by saying that, I can't remember what the percentage is, but the chances of changing the judge's view are very, very slim, is the polite version. But in reality, this is your opportunity to put the strengths of your case for the respondent and for the claimant in turn to the judge. So what you're trying to make is your best points, and if you can, to address any negative points that have been made. And that's probably the more important. It's to challenge and to give your evidence on your weaknesses, because that is the bit where you're going to tip the balance, if you're going to tip the balance at all. There's no formality to it. The judges sometimes ask questions, just the points they want to clarify. The last one I was at, he didn't want to hear any repetition of the evidence. He just wanted brief submissions on the law. So yeah, what we need to do now is together try and come up with the key points that you wish to make in favour of each party.
So we've helped out here a little bit, and we've got three submissions on behalf of the claimant first. So we'll go back to Mentimeter. We've given you three options in no particular order. What we'd like is your view as to which is the strongest on behalf of the claimant. So we'll do that first, and then we'll hear any other observations on the chat in a moment. So let's do the claimant's closing submissions first. So I'll just reshare my screen. Same Mentimeter for those of you who are still in it. If you just, you'll see it'll flick on to the next question. For those of you who need it, I will just show you voting instructions again. I think this is the closest I've ever seen the first and second
I've
one,
not
don't
seen,
you?
yeah, I've not seen them jump around quite as much, no.
Wonderful. So, Stephen, talk us through the significance of the difference between the first and the second one, seeing as these are our most popular. Neither are incorrect. None of these are incorrect, are they, in terms of the points being made?
Yeah, I think this reflects the swing that we saw in the Mentimeter poll. I think it's more a case that the respondent here hasn't been clear enough in the evidence. And point 1 and 2, whilst they are distinct, actually, they both reflect the failing in the evidence of the respondent's witness and the lack of documentary evidence. So I noticed on the chat, lots of people were saying should have had the conversation. Not only should they have the conversation, it should have been documented. There was no evidence of the complaint in the bundle to even back that up. Now, Tim didn't go into that at all. But if that was the reason, where's the evidence of that complaint?
Yes, quite.
So, you know, you've really got to start from the beginning and documentary evidence. And without that, then it may have been assumptions on the part of the claimant, but sympathy often lies with the claimant in these cases. If there's a benefit of doubt, then they'll probably go with the claimant. Particularly in relation to the Polish power suit comment, it was so unusual that it's not one that somebody would make up. So sometimes I've seen, and I've actually run cases on that basis, is that it's, you know, you might have denied it, but actually it's so detailed or it's so precise in what's been said that actually it gives it an element of strength when you put it forward. So
that sort of thing is not easy to make up, is that?
No, absolutely. Exactly. It's odd, and because of its oddness, it's something you wouldn't normally make up. I think Luke, the delegate, I think his name was Luke, actually said the advocate should have leapt on this change in language that she used on the stand. That would have undermined it. I think points 1 and 2 are very close, but I think that's due to failing the respondent's evidence.
Absolutely right. Yeah. So, and the second point specifically here is that the respondent has not satisfied that reversed burden. Is a key point here, isn't it? And this is then showing that the assumption ran all the way through it. So it not only satisfied the claimant's initial burden, but also it did not allow the respondent to satisfy their burden, that it had nothing to do with it.
Yeah, I wouldn't say it's common, but you do find it in a lot of cases where individuals raise not just one element of protected characteristic, they'll raise 2, sometimes 3. Rare that they go beyond that, but actually what they're doing is they're throwing so many things to stick, and in this case some of it stuck. Yes.
Yeah, quite so. So let's look at these submissions for the claimant in relation to the harassment complaints. Let's have a look at that one next. Interesting. So a clear front runner here is the can't recall point, the point we were discussing previously, wasn't it, in terms of the balance of probabilities and the relative qualities of the evidence.
I think we emphasise that in terms of discussion. That's one point I would say here is that irrespective, the lack of recollection, and I also think the body language, a lack of confidence, whereas the individual claimant got quite emotional. You could hear the voice got quite emotional at one point, but she was very categorical on what was said. She was certain the statement was said, even if it was an odd statement. That's what I heard, and that tips the balance. I always refer to this on my training courses, so apologies to those that may have attended before, but I remember a particular hearing. I just joined a company as an in-house lawyer, and my witness made what I thought was a negative point, one of those you just want to bang your head on the desk. but the judge, I remember saying, said, look, they struggled to come to a decision, but they preferred the evidence of, and they preferred the evidence of my witness because she'd been quite detrimental in her evidence to herself, but she was honest. It was
Yes.
that degree of honesty that swung them, and they just said, you know, we accept that she may be a firm manager, but she's not a bully.
Yes.
So they really go on who they like and what they don't like if the evidence is unclear. And the clearer you are, and the more categoric you are and reasonable you are, the better.
Indeed. Okay, let's have a look at the respondent submissions then, and then we'll get to the judgment. So what are the strongest points for the respondent's submission about the discrimination complaint? Have a look at these for me and tell us what you think is the strongest point. This is very interesting. So let's have a look at this one. She did not suffer detriment. We could have adjusted her target. So the point here is she jumped too soon. She didn't suffer a detriment as a result of this, which is a very interesting observation.
Strange enough, I would have put that last.
Yeah, it's interesting. Yeah.
And now that's the difference between common sense and legal argument. So what I would have run is, look, this wasn't anything to do with ethnicity or heritage. But in any event, if you're not agreed with me that there was a good reason, there was a complaint, she was suitably qualified. In any event, she did not suffer a detriment, because would be my final argument. But
yes,
I go
so
with
you
the
would
majority.
Have two and one in that respect, second and first. Yeah. And interestingly, the fourth one, which is the least popular, but it is often the one that you hear said anecdotally about these sorts of cases. Oh, well, that was the true reason, but it obviously rightly did not feature in this case. But you can see often that does play through in particularly in managers' minds when this sort of thing happens. Let's have a look at the harassment complaint then, and then let's make some decisions. So what's the strongest point of the respondent's submissions in terms of this harassment complaint? This is a difficult one, I think, don't you, in terms of submissions? I
do, because it's so subjective. So if we think about the definition of harassment, it's something that has caused or is likely to cause offence in plain English, or affect somebody's dignity. And if it was, that would be bullying, and it becomes harassment if she can link it to her nationality in this case. It's very difficult to go around, and that's that last point there. No reasonable person would have been offended. That's a very, very thin argument to run in reality, because it's looked at through the eyes of the individual. It would have to be an extremely strained grievance, or a totally unreasonable grievance for it not to tick that box of amounting to affecting someone's dignity and harassment.
And related to a protected characteristic. By dint of the reference to a Polish power suit, assuming the evidence goes in favour that it was said, it's very difficult to say that it's not related to it.
Yes.
I do remember somebody saying to me, which I thought was a very valiant argument, it could have been a polished power suit, which I thought was super. I so wish I thought of that when we were writing this case.
That sounds like a barrister's argument. I like that.
Doesn't it just?
Yeah, it might be wrong, but here it is. Yeah.
Indeed.
Yeah, I think this point of relying on there's no evidence, that's a difficult one, because that allows the judge and the tribunal to go either way. There's no evidence to say it did or it didn't. So I actually think point 2 for me, she didn't speak up at the time. If she was that offended, why wasn't it raised at the time? Why didn't you mention it to anybody, and why has nobody supported that evidence? This is simply a fabrication, might be my stronger argument, but it's choices, and this is the strategy you need to work out when you're working with your lawyers on these sort of cases. Work out what your strategy is, where's your weakness, and how are we going to address that? And you need to have that conversation before you start thinking about your statements, really.
Yes, indeed. Okay, so let's see what the outturn of this case is then. So normally,
sorry to interrupt, Vicky. Can I just?
Fire away.
There was one point I keep meaning to address it. Now, there was somebody put in the chat about surely the lawyer should have a dummy run. I would always have a pre-hearing meeting with my witnesses, and I'm sure you did as well, Vicky. The difficulty you've got is we can't encourage you to tell an untruth. Secondly, it depends on the witnesses. Some witnesses will not be coached. They will not. I had a very senior person, MD, that refused to go through the statement. We had to put his arm up his back. Turned out to be the worst witness I ever had. He read it like a 3-year-old. So some people will not be coached. Some people will be coached, and then they become too fixed and unrealistic, and therefore don't come across as an authentic and honest witness. So it really depends on your witnesses. It really depends. I think the key thing is not to coach or to do dummy runs, but just to say, look, you're going to be pushed on this area. Think about your answer. You can help them and help them think about how they're going to answer it. But there's a fine line between changing the evidence and actually unnerving the witness by forcing them. But definitely have a pre-hearing meeting. Don't just walk up to a tribunal and meet your advocate in the tribunal room.
And certainly what we can do is provide training for witnesses, give them the experience, explore the techniques, think about how they would deal with a situation, which is not about coaching them how to answer it, but also, but it is about giving them a sense of understanding the process that they are going through. Yeah. In that sense, you can certainly do that.
Yeah, that's on the chat as people. I think there's two.
Yeah.
Yes, witness. The answer is yes. We can give training on witnesses, particularly if you go to a hearing. It's worth having that training.
Yeah, absolutely. Okay, so what would normally happen would be there'd be a short adjournment while the judge reflected and made their decision. Normally, they will write their decision out. So I'm going to give you as close to a realistic as I can in that sense, to give you a sense of it being read out. Often what happens in that judgment is you don't get the actual decision until the end of having sort of run through the evidence. I'm not going to do that today because I do think it is useful to hear the decision and then hear how the evidence is being explained in the context of the decision. So I'm going to slightly adjust what some judges do, not all of them by any means. Obviously, it's a personal thing, but let me give you pretty close to the reality, taking into account the points that you've just given us in these closing submissions. This is the judgment of this mock tribunal in the case of Agnieszka Trosowska and Randolph and Tanner Interiors and James Fletcher. The tribunal has heard evidence under oath from the following witnesses: Agnieszka Trosowska, the claimant, and James Fletcher, the second respondent, and a manager at the first respondent. From the evidence heard, this tribunal determines as follows. Direct race discrimination. The claimant was subjected to race discrimination. This claim is well-founded and succeeds. Harassment. The claimant was subjected to harassment on grounds of race. This claim is also well-founded and succeeds. And here are the reasons for the decision. The claimant claims that the reason for her treatment is her race. Section 9 of the Equality Act has a non-exhaustive definition. It says that it includes colour, nationality, and ethnic and national origins. The claimant identifies as being of Polish ethnic origin for the purposes of this claim, albeit she has made clear to us in evidence that she was not a Polish national. The House of Lords, now the Supreme Court, has given us guidance in Mandler and Dowell-Lee that the question of ethnic origin is to be interpreted widely. I am satisfied that the claimant's heritage, Polish, amounted to an ethnic origin. Direct discrimination, the relevant law, is in Section 13 of the Equality Act, and it is that a person discriminates against another if because of a protected characteristic, A treats B less favourably than A treats or would treat others. In terms of the burden of proof, section 136 of that same act says that I have to ask myself two questions. One, are there facts from which this court could decide, in the absence of any other explanation, that discrimination has occurred? And if so, two, did the respondents not discriminate? There is guidance from the Court of Appeal in Mandrassi and Nomura International PLC that the burden of proof does not shift simply because the claimant has demonstrated a difference in national origin and a difference in treatment. Those bare facts only indicate a possibility of discrimination, and that there is, and not without more, if there's sufficient material from which this tribunal could conclude that on the balance of probabilities, the respondent committed the unlawful act of discrimination. The claimant must show a difference in national origin and a difference in treatment and a causal connection between those two. Then, if the burden does shift, the Court of Appeal tells us in Aigen and Wong that it is for the respondent to prove to this tribunal that the reasons for the treatment were in no sense whatsoever because of the claimant's national origin. So, why was the claimant selected to manage the emerging market in Poland? The claimant has relied on the fact that she was of Polish heritage, and it is the respondent's submission that it was an assumption on her part that the reason for her selection was her experience from her previous role. I'm required to consider what the evidence indicates on the balance of probabilities was the conscious or subconscious mental processes of the respondent in selecting the claimant to manage that emerging market. This tribunal has heard argument from the respondent that by selecting the claimant, they were selecting their best player. Yet the respondent has advanced no evidence to demonstrate any objective assessment of the claimant's abilities in selecting her for this task. Furthermore, Mr. Fletcher admitted in evidence that other members of the team had more experience of developing new markets. I therefore draw the inference that the claimant's Polish ethnic heritage was relevant to Mr. Fletcher's having chosen the claimant. Furthermore, we've heard from Mr. Fletcher, the claimant's manager, that there had been concerns about her communication style that he thought might be cultural, and that she might prefer working on this task. In his evidence to this tribunal, Mr. Fletcher sought to distance himself from that previous conclusion that the communication issues were cultural, but I am not satisfied that the respondent has established that the claimant's selection was in no sense whatsoever because of her national origin. In doing so, I recognise that discrimination need not be ill-intentioned and can be based on an assumption, for an example, that someone would be a good or a better fit, or that behaviour is due to culture. Was that selection adverse or detrimental? It's the respondent's case that the selection of the claimant was not adverse or detrimental to her, but the House of Lords has given us evidence, given us guidance on the meaning of detrimental treatment in Shamoon and the Chief Constable of Royal Ulster Constabulary, where it was held that a worker suffers a detriment if a reasonable worker would or might take that view. And the claimant in her evidence referred to a lack of support to develop a new market and the fact that the claimant's target was not adjusted to reflect that Poland was a new market. Whilst the respondent's case was that the selection was in fact more favourable to her in that it was making positive use of her experience, Mr. Fletcher admitted in evidence that other members of the team had prior experience of establishing new markets, whereas the claimant did not. I'm therefore satisfied that on the balance of probabilities, choosing the claimant without giving her support, whether in the form of reducing her a target or in other ways, was detrimental and amounted to less favourable treatment. Turning to the harassment complaint, we have heard from the claimant that Mr. Fletcher used the phrase Polish power suit in the team meeting, which she described as making her feel embarrassed and angry. Mr. Fletcher's evidence, he says that he does not recall using the word Polish, although he does remember making some reference to the claimant's clothing. Neither party has called evidence to assist the tribunal in respect of this allegation. We have found the claimant to be more specific, consistent, and detailed in her evidence compared to Mr. Fletcher, and as such, we prefer the evidence of the claimant. We therefore conclude on the balance of probabilities that the phrase Polish power suit or Polish power outfit was said by Mr. Fletcher. We also accept that the comment creating an adverse environment for the claimant and accept her evidence that she felt it created a hostile environment for her. We are mindful that this is a one-off incident and yet find that it is reasonable to regard that the conduct as having that effect on her, particularly taking into account the surrounding circumstances. This concludes my judgment. A further hearing will be arranged at a later date on the question of remedies, including to consider the issue of a lack of compliance by the claimant with the ACAS code of practice as far as raising her complaint internally and any potential reduction in compensation. So it's a win for the claimant on this particular case. Now, ordinarily, what would happen would be people would just disappear at this point. There would be no further discussion. We've obviously got the benefit of talking about it, but immediate thoughts on the chat would be so valuable to hear in terms of thoughts on that decision. I'm conscious that this tribunal is at risk of outstaying its welcome, Joe. So I'm going to bring it to a conclusion there with thanks for all the comments and observations on the chat. It makes such a difference. We are going to send you some resources, some are around on performance management. How do you manage these sorts of conversations? And Stephen, I know that for those of you that are employers in the room, because as a business, we act for some of the UK's largest employers. If you have questions on tribunal, cases that you've got upcoming, and happy to sort of spend some time with you, just drop us a note and we'll happily link in with us and we'll happily arrange that for you. But I don't want to take all the time. So Joe, I'm going to hand over to you to close up for today.
Brilliant. Thanks very much. Wow, what a good couple of hours that was. How interesting and exciting. So I'd just like to say a massive thanks to Vicky and Stephen for all the effort that you've put in. Yeah, really interesting. And I'm glad that, I'm sure that everybody else has thought the same. So I'm going to send out an email to everybody that's registered following the event. This will include links to the Vista's resources that Vicky's just referred to, and this will be useful for you following today's session. I'm also going to put a post on LinkedIn for you to add a comment about the session, and also if you would like a copy of the recording, then add your comment to that LinkedIn post. In terms of HR Recruit, we also run a guild networking group for HR professionals. It's a bit similar to WhatsApp, where members can ask questions, network and share ideas. I think we've got about 700 people registered in there, so the link to sign up for that will be on the email. And finally, if anyone is actually recruiting, then within the group, we've also got accountancy recruit and finance director recruit within the group. But finally, I'd just like to say a massive thanks to Vicky and Stephen for the time, and also to everybody for tuning in. Thanks very much, and I hope you've enjoyed it.